Hi there, I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Okay, now we're on part 2 of the Chapter 12 Bankruptcy. Under the code, this is for adjustment of debts of a family farmer or family fisherman with regular income. So this will be part 2. What we're covering is on this page. We're going to look at the Chapter 12 plan, the hearing, trustee's distribution of payments under the plan, modification of the plan after confirmation, revocation of order of confirmation, conversion or dismissal, discharge, revocation of the discharge, closing the case, and proceedings after the case is closed. So the Chapter 12 plan must show how part or all of the creditors allowed claims are going to be paid from future earnings in the sale or surrender of collateral. It needs to be filed within 90 days after the order for relief unless the bankruptcy court grants an extension, and only the Chapter 12 debtor may file the plan. If the debtor doesn't file the plan timely, the trustee or a creditor may move and ask for the court to dismiss the case. Its contents there's a must and there's a may. And the must, of course, is the mandatory. The may is the permissive. So we can look at 11 U.S.C. Section 1222 and compare those two subsections, A and B. The mandatory provisions are that the Chapter 12 trustee must provide for the Chapter 12 trustee to have supervision and control of the portion of the debtor's future income necessary for the implementation of the plan. And the plan must provide for full payment of all priority claims. There are some exceptions, as we always have seen. And it must provide the same treatment for each claim or interest within a particular class, if claims and interests are classified into classes. It must provide for payment of less than all domestic support obligation owed or assigned to a governmental unit if the plan provides that all of the debtor's projected disposable income for a 5-year period will be applied to payments under the plan. And the payment period under the plan must not exceed 3 years unless the bankruptcy court approves a longer period, and then no longer than 5. So another similarity, 3 to 5. Those areas of the Chapter 12 plan that are permissive, they may designate a class or classes of unsecured claims. They may modify the rights of holders of secured and unsecured claims. The plan may cure or waive any default. The plan may propose payments on unsecured claims concurrently with payments on the secured claims or other unsecured claims. They may cure default of a secured or unsecured claim on which the final payment is due after the proposed final payment under the plan. The plan may provide for assumption, rejection, or assignment of previously unrejected executory contract. And the plan may provide for payment of all or any part of any claim from property of the estate of the debtor or the debtor. Continuing on with permissive, and these permissive provisions really show you the finer tuning ideas that the problems that get dealt with. Chapter 12 may be chosen not just because of eligibility criteria, but some of these nuances that can be included in the plan that protect the debtor in the whole scheme of things in business. Anyway, the plan can provide for the sale of any part of the property in the estate or its distribution among those having an interest in that property. The plan may provide for payments of allowed secured claims, looking at 11 U.S.C. Section 1225A5 over a period exceeding the 3 or 5 years of the plan. And the plan may provide for the vesting of property in the estate. And the plan may include any other provisions not inconsistent with other Title 11 provisions. And I think there's one more. So the plan may provide for the payment of interest accruing after the filing of the petition on non-dischargeable debts, but only if the debtor has disposable income available to pay such interest after making full provision for the payment of all allowed claims. I know it's a lot of complicated stuff. Be perfectly honest with you, know the mandatory provisions. There are a lot of permissive ones under Chapter 13 and Chapter 12. You can sit and try to memorize all of those or make a short list of these long statements, but really the mandatory provisions, when that, you're doing well. The payments under the plan. The debtor makes payments to the trustee, just like in Chapter 13, but unlike Chapter 13, there's no period set for the debtor to begin making payments to the trustee. That'll depend on when the debtor has income. So again, looking at this like a business, not like a Chapter 13 where they walk in there as mostly individuals and co-debtor, and spouses of an individual. The look forward is a little different than that in Chapter 13 versus Chapter 12. Once payments begin, the trustee retains the payments until the plan is confirmed. The plan can be modified, the plan at any time before confirmation, and it has to meet the same requirements as the original plan. And the holder of a secured claim that's accepted or rejected the original plan is deemed to have accepted or rejected the modified plan unless the holder's rights have been changed by the modification. There is a hearing to confirm the plan, just like in Chapter 13, and it has to be concluded no longer than 45 days after the plan's been filed. In the Chapter 12 trustee, the creditor, or the United States trustee may object. And to be confirmed by the court, the plan must comply with 11 U.S.C. 1225A. So, what are those requirements? The plan must comply with these provisions, fees and charges. The fees and charges required by Section 1930 are required by the plan must be paid. The plan must be proposed in good faith. And the payments of the unsecured claim must fulfill the best interest of the creditor's test. So don't forget that best interest of the creditor's test. That's where we look at it compared to a Chapter 7. Because everybody's still going to come out the same. So best interest of the creditor's test. Moving on to additional requirements on this page. A secured claim can be treated in more than one way. They can treat the claim so the creditor will accept the plan, surrender the collateral to the creditor in full or partial satisfaction of the claim, cram down the plan on the secured creditor. The plan must provide that the creditor retain the lien securing the claim and that the secured claim will be paid in full with interest. Let me see if they cram down what they say in that list of definitions, also known as pennies on the dollar. The cram down occurs when the plan in a Chapter 11, 12, or 13 case is approved over the objection of a creditor or class of creditors by the vote of other creditors, usually resulting in a debtor paying less than 100% of its unsecured claims. And then an example, XYZ Bank has $150,000 loan on real estate valued at $100,000. A cram down plan would leave XYZ Bank with only $100,000 secured lien, and the remaining $50K would be treated as a general unsecured debt. So all or a portion of that $50K may not get paid. Considering that we classify, so there could also still yet be a classification for unsecured claims in the plan, and that $50K would be aggregated with the other unsecured claims, and based on the math, based on the test, and the income to monthly payment, I'll just call it that. Looking at that test, whether that's feasible is what ultimately they're looking at. That could end up, there may be a portion of unsecured claims. So what I'm getting at is that $50K may be unsecured does not necessarily mean it clearly won't get paid. All right, more requirements. They need to show that they're able to make the payments under the plan and comply with the plan, and the debtor must pay domestic support obligations that first became payable after the filing of the petition. So that concludes those on 11 U.S.C. 1225 requirements of the plan. Trustee's distribution of payments under the plan. So if the plan is confirmed, the Chapter 12 trustee distributes payments to creditors in accordance with the plan. And if it's not confirmed, they return the payments to the debtor. Same thing in Chapter 13. Modifying the plan after it's been confirmed, it can be a request can be made by the debtor, trustee, or a holder of an unsecured claim. And the holder of a secured claim may not request modification of the plan. So it's very interesting, isn't it? Probably because, I'm just going to guess why that may be. Probably because the plan's been confirmed and the testing that goes on doing that confirmation, it has to be in a secured claim. This is the amount, it's I guess, quid pro quo. It is what it is. Revocation of the confirmation order, conversion, or dismissal. A party in interest can request the court to revoke an order of confirmation if the order was procured by fraud, and it has to occur within 180 days after the order. A full compliance discharge, that's what the debtor is looking for, and after completing the payments under the plan, the debtor will receive a discharge, but not be discharged from allowed secured or unsecured claims not provided for by the plan. So if it's not in the plan, there will be it's not allowed there. Okay, so try to imagine when you see this type of statement. It's like the plan provides for all this to be paid, and it includes secured and unsecured claims. So there's a standard already set by the plan. And then what's left after that standard, so if it's, let's say the plan provides for $1 million worth of secured and unsecured claims be paid, but the debtor had $2 million worth of them, the discharge would happen on the other half because the 1 million. So you got 2 million minus 1 million that are allowed and under the plan. And so the leftover is another $1 million, and that would be subject to being discharged. And any debt, this is the idea, getting as much debt discharged as possible. The debtor won't be discharged from, okay, so the plan, no, you're not discharged from what you paid under the plan. That's that first bullet point right here. But everything else is, in that scenario I just gave, about $2 million. Any debt for the curing of any default on any secured or unsecured claim on which the final payment is due after the proposed payment under the plan. So the debtor might go to a bank and get and secure a debt to cure a default on the secured or unsecured claims. They're obviously not part of the plan. So that debt is not part of the plan. So it's not intended to be a debt that would be discharged because it occurred after the proposed final payment under the plan. Because it occurred after So the non-dischargeable debts include that are more listed in 11 USCA Section 523. There is, like in Chapter 13, an opportunity for a hardship discharge. Take a look at this on your own, reading the PowerPoint. Pretty simplified slide. Let's see. And so they still receive some discharge. They may not get as much of a discharge. So that is possible too. To revoke the discharge, a party in interest may request such for, I think they file a motion. I'm not sure if it's a motion or a complaint. So if there was known fraud after the discharge was granted. And then closing the case, the trustee will do a final report, an account, certify that the case has been fully administered, and finally, the closed case can be amended without being reopened, and a closed case can be reopened. So sometimes there's some clerical errors to fix, so we don't need to reopen the case and have a whole lot of work to do around nothing, right? But the errors on the judgments, orders, documents, scrivener's errors, okay, those can be done, or oversight or omission type things. And a closed case can be reopened if a creditor is found and needs to be added, or to distribute previously undistributed property of the estate. So that concludes Part 2, the Chapter 12, Bankruptcy. And I'm going to tell you that I found that quite painless, especially after describing Chapter 13, having not touched a Chapter 13 case for a lot of years. But it all came back to me as I studied, got myself prepared to do this section of the course. So thank you very much, and that closes Chapter 12, Bankruptcy Code. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also, there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.